Good morning, everyone, and welcome to another edition of the Senate Committee on Commerce and Labor for the 81st Legislative Session. Madam Secretary, please call the roll.
Senator Hardy.
Here.
Senator Lang.
Here.
Senator Neal.
Here.
Senator Pickard.
Here.
Senator Scheibel. Here. Senator Settlemeyer.
Here.
Chair Spearman.
Here. Thank you, and want to welcome our audience who's joining us remotely. Today we have hearings on Assembly Bill 277. We have a work session on Assembly Bill 45, 47, 73, 173, 200, 308, 327, 366, 442, and Assembly Joint Resolution 10. And I see the speaker here. With deference to you, we can let you go first, Speaker. Is that okay? Yep. Okay. All right. So once we get finished doing all the other housekeeping stuff, everybody turn your phones off, turn your laptops off. Well, you can keep them on. Just don't make sure they don't make noise. The legislative building is open. Under certain circumstances, people can come in and mingle and sit and see and talk. But you must have your mask on. So if you are not able to get in, there's still some ways that you can participate. You can register through Nellis. You have the opportunity to testify on a bill, submit written comments, share your opinion via the legislature's opinion application on Nellis, and you can view committee meetings through Nellis or on the legislature's YouTube channel. To register on Nellis, click participate on the meeting and the time, and once you do that, then you will see information, receive an email confirmation. It will give you the email and the telephone number to call at the time of the meeting. If you request to participate in person, you will receive additional email with instructions on entering the building. Just like we have in other sessions, just because you sign up does not mean that you will be able to speak. That's why I ask people, if we are hearing a bill, if someone has already covered the points that you want to make, please just say ditto. That gives more people an opportunity to speak during that time frame. When you're on the telephone, please pay attention. Please pay attention. Please pay attention to the bill that is being discussed and follow the verbal prompts by the staff, and they'll call on you to speak by your last 3 digits of your phone number. If you need assistance with any of these processes, you can email us on the email address that's listed on the agenda. All exhibits must be submitted in electronic format no later than 8. And if you are submitting an amendment, I will not accept or entertain any amendments if the sponsor of the bill is not aware of that amendment. When you testify, unmute your microphone, project your voice, and speak clearly. Reminder to everyone who testifies, and that's whether or not we ask a question during the work session or I think we have 2 bills remaining. 1 bill. Remaining. Yeah, 1 bill remaining. So once you open up the mic to answer a question, anyone who knowingly misrepresents facts when testifying before a legislative committee, according to NRS 218E.085, is guilty of a misdemeanor, and myself or any member of the committee can ask you for documentation to back it up. Friday, May the 14th, is Second House Committee passage deadline. And so all of you who have bills that have already been presented, if there is an amendment that you're waiting on, please tell whoever you're waiting on that you have got to hurry up, because whatever's not out of here on Friday will go into the round file. So make sure that you do that. So I'll tell you what, let's open up with the Speaker's bill. We'll do a work session on that, Assembly Joint Resolution 10.
Assembly Bill 308 first.
Oh.
Got 2.
You guys got 2? Well, I think he said he has to go.
He's got 2 bills.
You got 2 bills? Okay, all right. My bad. I'm looking at you, I'm like, okay, 308. Back up, and let's start again. Good morning, Mr. Speaker. We're going to open up with Assembly Bill 308. I'm thinking about AJR 10, you know that?
Thank you, Madam Chair. For the record, Cesar Melgarejo, Committee Policy Analyst, and our first bill in the work session today is Assembly Bill 308, which revises provisions relating to landlords and tenants, and it was sponsored by Assemblyman Frierson and heard on April 23rd, 2021. Because of the long agenda, I will skip the bill summaries, but Madam Chair, there are no amendments for this measure.
Committee members, any questions, clarifying questions, comments? Vice Chair?
No.
Okay. All right, so I think we are ready. Madam Secretary, please do a roll call vote.
You got to take a motion.
Senator Ratty, you're in my head again. I'll entertain a motion.
So moved, Madam Chair.
Have a motion by Senator Lang and have a second by Senator Scheibel. Additional questions? Now, Madam Secretary, please call the roll.
Senator Hardy,
Yes.
Senator Lang,
Yes.
Senator Neal, Senator Neal,
Yes, I'm having trouble.
Senator Pickard,
No, but I'll reserve my right.
Senator Scheibel,
Yes.
Senator Settlemeyer, Chair Spearman.
Yes, and let the record show that the motion passes unanimously with one reserving a right to change their mind. Thank you so much. And Senator Lang, you want to take that? No, Pickard, you said,
I said no and
Oh.
reserve my right.
Okay,
I
no.
just, I'm waiting for some response from the rental community. I just feel like there's been an awful lot of pressure on landlords, and so right now I'm just not comfortable. Thank you.
okay. So we've got 6 and 1 reserving the no, and then 1 reserving the right. So the motion passes. Senator Lang, you want to take that?
Yes, thank
Okay.
you.
Thank you. Okay. Thank you.
Thank you, Madam Chair. Cesar Melgarejo, Committee Policy Analyst. Our next measure is Assembly Joint Resolution 10 of the 80th 2019 session, which proposes to amend the Nevada Constitution to prospectively increase the required minimum wage paid to employees. It is sponsored by Assembly Committee on Commerce and Labor, and there are no amendments to this measure.
Committee, questions, clarifying questions, comments? Okay, with that, I'll entertain a motion. Motion?
Do pass.
Second?
Have a motion from Vice Chair Neal and second from Senator Pickard. Any additional questions,
Comment, if I could, Madam Chair.
comments? Yes, please.
Thank you. I was actually one of the people who was the first person in this building to find out that we had the ability as a legislature to raise the minimum wage as a body. And if that's the intent, I think as a body, we should make that decision rather than to have it to take it to the vote of the people and then basically create a situation where it's another 2 years. In Northern Nevada, it doesn't make much difference in all reality. You can't find somebody for $12 if you had to. That's just a reality. You can listen to the radio all day long, advertising jobs for $16 an hour. So in that respect, I'll be voting no today because I think this is just about putting it to the ballot. When if our job is to worry about the people, I think we ought to do it as a bill rather than just doing it on the ballot. Thank you.
Thank you. Additional comments? And Senator Settlemeyer, I hear and I understand that. I'm going to go back to, I think it was 2013 when we first started this conversation. And a number of people were like, well, why are you all doing it? You ought to let the people vote on it. So I guess it's like, so the one thing that you can say to people is that we did vote to give them their voice. Fair? Okay. Mr. Speaker? Okay. All righty, so we've had a motion, Senator Pickard, and a motion by Vice Chair Neal and a second by Senator Pickard. All those in favor, I'm sorry, Madam Secretary, please call the roll.
Senator Hardy,
No.
Senator Lang,
Yes.
Senator Neal,
Yes.
Senator Pickard,
Yes.
Senator Scheibel,
Yes.
Senator Settlemeyer, Chair Spearman.
Yes? Okay, so the motion passes, and I'll do the floor statement. Okay. Thank you, Mr. Speaker. Mr. Melgarejo?
Thank you, Madam Chair. Cesar Melgarejo, Committee Policy Analyst. Our next bill is, we'll go back to the top of the order for Assembly Bill 45, which revises provisions relating to insurance. And the bill is sponsored by Assembly Committee on Commerce and Labor on behalf of the Division of Insurance of the Department of Business and Industry. It was heard on April 28th. Madam Chair, there is an amendment proposed by you, which does the following. Adds a new transitory section to the bill to allow an association of self-insured private employers be deemed to be in compliance with the requirements of subsection 2 of Nevada Revised Statute 616B.353 if the association meets certain requirements. And number 2 is to amend section 87 to provide that the new transitory section is effective upon passage and approval for all purposes and expires by limitation on June 30th, 2023. Madam Chair, we do have the Insurance Commissioner on Zoom if you have any questions.
Thank you. Committee, questions? Senator Settlemyer.
Thank you, Madam Chair. I appreciate all the hard work that you did with this amendment to get the parties to a place where both of them are a little bit unhappy. But in that respect, that probably means it's good law. In that respect, if you'd take a motion, I would amend to pass.
So we have a motion from Senator Settlemyer, amend to pass. I have a second from Senator Hardy. Additional questions or comments? Okay. So with that, Madam Secretary, please call the roll for the vote, please.
Senator Hardy,
Yes.
Senator Lang,
Yes.
Senator Neal,
Yes.
Senator Pickard,
Yes.
Senator Scheibel,
Yes.
Senator Settlemyer, Chair Spearman.
Yes, and let the record show that the motion carries unanimously. Senator Settlemyer, you want to take the floor statement? Thank you.
Thank you, Madam Chair. Cesar Melgarejo, Committee Policy Analyst. Our next bill is Assembly Bill 47, which revises provisions relating to unfair trade practices, sponsored by the Assembly Committee on Commerce and Labor on behalf of the Attorney General. And it was heard on May 5th, and there are no amendments to this measure. And we do have individuals on Zoom who can answer questions.
Thank you. Committee, questions, clarifying questions or comments? And with that, I'll entertain a motion.
So moved.
You pass.
So we have a motion from Vice Chair Neal and second from Senator Lang. Additional questions? Thank you. Madam Secretary, please do the roll call vote.
Senator Hardy,
No.
Senator Lang,
Yes.
Senator Neal,
Yes.
Senator Pickard,
No.
Senator Scheibel,
Yes.
Senator Settlemyer, Chair Spearman.
Yes? Thank you, and the motion does pass. Vice Chair Neal, you want to take the floor statement on that, please?
Sure.
Yes?
Yeah, I'm like, am I not coming through? Yes.
Yeah, you are now. When you say yes, you don't come through. When you say yeah, it comes through.
Oh, see, that's just mean.
Cesar Melgarejo, Committee Policy Analyst for the record. Our next bill is Assembly Bill 73, which revises provisions relating to licensure of dietitians and is sponsored by Assembly Committee on Commerce and Labor on behalf of Division of Public and Behavioral Health of the Department of Health and Human Services, and it was heard on April 26, 2021, and there are no amendments to this measure.
Thank you. Committee members, clarifying questions? Comments? Okay, so I'll entertain a motion. I have a motion from Senator Hardy. Do I have a second? Second from Senator Scheibel. Additional questions? Madam Secretary, please do a roll call vote.
Senator Hardy,
Yes.
Senator Lang,
Yes.
Senator Neal,
Yes.
Senator Pickard,
Yes.
Senator Scheibel,
Yes.
Senator Settlemyer, Chair Spearman.
Yes. And the motion passes. Senator Scheibel, you want to take the floor statement? Okay, thank you. Okay.
Cesar Melgarejo, Committee Policy Analyst. For the record, our next bill for work session is Assembly Bill 173, which revises provisions relating to professional engineers and land surveyors. This bill is sponsored by Assemblywoman Howdigi, and there are no amendments to this measure.
Thank you. Committee, clarifying questions or comments? I'll entertain a motion.
Move to pass.
Have a motion from Senator Lang. Second.
Oh, Senator Scheibel who moved to pass.
Okay.
And
Senator
I'll
Scheibel.
second.
Okay. Senator Scheibel, you did the first one, amend do pass?
Yes. No,
Okay.
just do, isn't it just do pass?
Yeah, do pass, it's just do pass.
Yeah, second.
Lang is, made the motion, and Senator Scheibel made the second. And so, Madam Secretary, please do the roll call vote.
Senator Hardy.
Yes.
Senator Lang.
Yes.
Senator Neal.
Yes.
Senator Pickard.
Yes.
Senator Scheibel.
Yes.
Senator Settlemyre. Chair Spearman.
Yes, and the motion carries. Senator Hardy, take that floor statement. Okay. We're gonna do a 5-minute recess. I have a bill that's coming up in the Assembly, and they're calling for me now. And once Assemblywoman Durand gets down, we will begin the bill hearing for her. And Vice Chair, if I'm not back by that time, if you can start the hearing.
Okay.
Okay, I appreciate it. No, you should have said, yeah. Okay.
Uh-huh.
Okay, so 5-minute recess, okay? We'll be right back. I'm back. So we'll come back from recess and we'll open up the hearing on Assembly Bill 277. And I see Assemblywoman Durand, you are here and ready. Begin when you wish. Thank you.
Good morning, Chair Spearman and committee members. For the record, I am B. Duran, representing Assembly District 11.
Do me a favor, pull the microphone a little bit closer.
Okay. Okay, I am B. Duran, representing Assembly District 11. I'm here today to present for your consideration Assembly Bill 277, which helps streamline the personal injury claims process after a motor vehicle accident. There is an amendment available on Nellis that reflects both attaining justice for injured parties in a car accident, but also the process needs for practitioners and insurance companies. Chair, with your permission, I would like to turn over the remaining presentation of the bill to Graham Galloway with the Nevada Justice Association and Jesse Wadhams representing the Nevada Insurance Council to share background details for this measure and to address the technical aspects of the bill.
Thank you.
Good morning, Chair Spearman, members of the committee. Graham Galloway on behalf of the Nevada Justice Association. And in a rare and unusual situation, I have with me my colleague, Jesse Wadhams, on behalf of the Nevada Insurance Council. We're here to jointly present an amendment to the bill. And the amendment, I believe, is now on Nellis. The amendment clarifies the bill, simplifies the bill, and rather than spend a lot of time talking about the history of this bill or the background, I'm just going to talk about the amendment. The amendment deletes Section 1 of the bill. Section 1 had to do with what we call automobile medical coverage. And we realized that once we got into the discussion about Section 1, that we were going to create more problems than that we were going to resolve. So we decided that we would defer medical coverage, med-pay coverage for a later date after we've had some more time to think it through. Section 2 is what remains, and Section 2 just simply simplifies the pre-litigation obligations between personal injury claimants and the insurance carriers to whom they have presented insurance claims. Historically, for numerous years, we had a statute, NRS 690B024, which required the two sides, the insurance industry, the claimants, to exchange information pre-litigation. 2015, that statute went away. 2019, we brought back the statute, but we realized that there was some ambiguity in the language, and the amendment, the bill clarifies that. We go back to how it was forever, where insurance companies provide policy limits to the claimants provide medical records and authorizations to the insurance company. That's what's taking place with the bill. That's what's taking place with the amendment. Thank you, Madam Chair.
Chair Spearman, excuse me, for the record, Jesse Wadhams with the law firm of Black & Wadhams representing the Nevada Insurance Council. It is an interesting time to actually, like my colleague Mr. Galloway said, to be sitting next to him jointly presenting a bill. Fortunately, there still is the glass partition here, which will mitigate any other issues. I think Mr. Galloway did a good job of sort of summarizing the issue. We have, litigated this issue in front of various Commerce and Labor committees over the course of a number of sessions, and very much the intent here is to create a simplified process whereby the insurer discloses certain policy issues and the claimant discloses their medical records so that you can understand both sides of the claim. And again, taking a cue from an earlier committee hearing for Mr. Keene's benefit, we have very much intended to create sort of a one-stop shop of just a sentence that says, do this, get this. And that is intended to simplify the process for all sides so everyone knows very clearly what they are to do. I'm happy to answer any questions.
Senator Pickard?
Thank you, Madam Chair. Just really a comment. I appreciate the fact that both sides have come to an agreement on this. This is something that's been debated not only in the Commerce and Labor Committee, but in the courts for years. And so I appreciate the fact that everybody's recognizing this is essentially what's going to happen once it goes to court, and this should simplify the process. So I appreciate that. Thank you, Madam Chair.
Thank you. Additional questions? Vice Chair?
Yeah, thank you, Madam Chair. So I only have like one question. So in the amendment, the redaction language, so it said personal and private. So I guess I was trying to understand the distinction between the two words and what would actually be redacted.
Madam Vice Chair, Jesse Wadhams for the record. You're probably right in that personal and private information may be a tad redundant. I guess I would leave it to the LCB drafters to make sure that they've clarified that personal information that is can be, sort of redacted, But the intent is to keep the name of the policyholder and the limits to be shown. So there may be other things on that page that are things like additional insureds are also on the deck page, things like the VIN numbers of cars. So it's intended just to simply protect the personal information, and I'm sure there's a vernacular or a legal term for that. That's the intent.
Okay. Thank you for that, Madam Chair.
Thank you. Senator Hardy?
Thank you, Madam Chair. I'm just wondering if it's appropriate to take a picture of the two of those guys.
I understand we have someone from Guinness on Zoom. Any additional questions? Okay. Is there anyone in the room? I'm sorry, Assemblywoman, do you have additional comments or? No, okay. Anyone here in the room that is here for support? Assembly Bill 277? Don't see anyone. So broadcast, let's go to the phones. 20 minutes per segment.
Thank you, Chair. Good afternoon.
2 minutes per individual.
If you would like to testify in support of AB 277, please press *9 now to take your place in the queue. Again, if you would like to testify in support of AB 277, please press *9 now. Chair, you have no callers in support at this time.
I'll go to opposition.
If you would like to testify in opposition of AB 277, please press *9 now to take your place in the queue. Again, if you would like to testify in opposition of AB 277, please press *9 now. Chair, you have no callers in opposition at this time.
We'll go to neutral.
If you would like to testify neutral on AB 277, please press *9 now to take your place in the queue. Again, if you would like to testify neutral on AB 277, please press *9 now. Chair, you have no callers neutral at this time.
Okay. Thank you. Assemblywoman, you have closing comments? Closing comments? Mr. Wadhams? No? Okay. All right. All right, so then we will close the hearing on Assembly Bill 277, and we'll go back into work session, but I don't see Senator Settlemeyer. So let's go to about a 5-minute recess, and we'll be right back. So we're back from recess, and we will continue now with our work session. Mr. Megalejo.
Thank you, Madam Chair. For the record, says our Margarejo Committee Policy Analyst. Our next bill on the agenda is Assembly Bill 200, and revises provisions governing veterinary medicine. It was sponsored by Assemblywoman Bilbray Axelrod and Senator Scheibel. There are some amendments to the bill. Liza Naveworth proposes the following amendments, which is to add a new section to the bill to amend Nevada Revised Statutes 638.017 to revise provisions requiring the Nevada State Board of Veterinary Medical Examiners to post a notice of a hearing or action in a newspaper if personal service cannot be made. Next is to add a new section to the bill to amend subsection 4 of NRS 638.100 to remove the requirement that an application be notarized. Number 3 is to add a new section to the bill to amend NRS 638.127 to provide for biannual renewals and revise various requirements for renewal. Number 4 is to add a new section to the bill to amend NRS 638.134 to authorize a veterinary technician to administer certain vaccinations for zoonotonic diseases. Number 5 is to add a new section to the bill to amend NRS 638.1429 to revise certain requirements governing the board's investigation and disposition of a complaint. And number 6 is to add a new section to the bill to add a new subsection to NRS 638.147 to authorize the board to adopt regulations which provide for the board to issue non-disciplinary letters of correction for certain violations. And Madam Chair, that's all the amendments.
Thank you. Have questions? Senator Hardy?
Thank you, Madam Chair. So on number 4 on the amendment, is that to give vaccinations to animals other than people or to people included?
For the record, through you, Madam Chair, to Senator
Just
Hardy.
go direct.
Thank you. Senator Hardy, my name is Alyssa Naveworth, and with me today is Jennifer Pettico, who's the Executive Director of the Nevada Board of Veterinary Medical Examiners, who's the ones requesting the majority of the amendment. But yes, I believe that is true. It's just for veterinary technicians to administer zoonotic vaccinations such as rabies to animals.
Thank you, Madam Chair.
Thank you. Additional questions? Comments? Senator Pickett?
Madam Chair, I move that amended to pass.
Wait. We got another. Senator Pickett?
That's fine, Madam Chair.
Okay. No, I thought you had a question. No question? Okay. Hold on, because I have a comment. I just want to. I promised some folks that I would look at some additional information on yesterday to see if that would change my opinion on the way this bill is written. And just want to say I don't see anything in Assembly Bill 200 that prevents additional veterinarians coming into Nevada, and I just don't think it's too onerous to have to establish a relationship. The first visit be a relationship. So that's why I'm going to vote yes. I don't think that it stifles business, and I don't think that it precludes anyone who wants to come in from doing that. So, for the record, those of you who asked me to take a look, yes, I did, but it didn't change anything. So, now, Senator Lang, you have the motion.
I move that amended to pass.
Okay, we have a motion by Senator Lang, have a second by Senator Pickert. Additional questions, comments? Senator Settlemyer.
Thank you, Madam Chair. I appreciate a lot of the work that's gone into this bill, trying to help some of the concerns that the Veterinary Board has had that they weren't able to get fixed in other pieces of legislation. It'll still maintain our standards and requirements to the FDA for programs and feed sources, so it's very important in that respect that the bill gets passed. I'm still very concerned that fundamentally, at 2 o'clock in the morning and you're out in the middle of nowhere, maybe a phone call with somebody is better than nothing. If you're trying to establish a vet, because the worst problem is with a veterinarian is sometimes you give them a call in rural areas and they're not around. They went out of town because, unfortunately, even my area, the vet's not busy enough with large animals that he actually goes to Elko or he'll go over to California, and then he's not around. Then you're trying to find a new vet at 2 o'clock in the morning, because for some reason that seems to be the time when things go wrong, at least on a ranch. And so I have some concerns. I'm going to vote yes on it with reservations, though, because I still need to try to talk to some more people about some concerns. Thank you.
Thank you. Response or no?
Thank you, Madam Chair. To you, Senator Settlemyre. We believe that the bill addresses that concern, and we will follow up with you, certainly. I believe it's Section 3, Sub 2, creates an exception for emergency situations. So the scenario that you just outlaid would absolutely be appropriately covered. And so you would be able to call a new veterinarian if you cannot access your current veterinarian in that scenario. But again, I will come and meet with you on that issue, and we really appreciate you working with us on this and your support of the bill with reservations.
Okay, thank you. So we have a motion, Senator Lang, second by Senator Pickard. No further discussion. Madam Secretary, please call the roll for the vote.
Senator Hardy,
Yes.
Senator Lang.
Yes.
Senator Neal,
Yes.
Senator Pickard,
Yes.
Senator Scheibel,
Yes.
Senator Settlemyre. Yes. Chair Spearman.
Yes, and the motion carries unanimously. Vice Chair, you want to take that floor statement?
Sure.
Okay, thank you.
Thank you, Madam Chair. Cesar Melgarejo, Committee Policy Analyst. Our next bill and work session is Assembly Bill 327, which requires certain mental health professionals to complete continuing education relating to cultural competency, and is sponsored by Assembly Members Torres, Nguyen, Brown May, and Senator Donate et al., and it was heard on May 4th. Senator Spearman did propose the following conceptual amendments, which is to add Senator Spearman as a joint sponsor and to amend sections 1 through 7.5 to require that the curriculum for the required training be based upon a range of research drawn from diverse sources, and that the instruction address persons who have certain different cultural backgrounds. And Madam Chair, that's all the amendments.
Thank you. Questions, committee members, comments? Senator Hardy?
Madam Chair, we're on 327, correct? So I asked a question, I think, during the hearing about accounting for ethics requirements. When we start looking at all of the different things that are adding up on specifics, we may be infringing on the competency of the care that we're trying to, was the original reason we're trying to make sure that they don't fall short of learning, relearning, and learning anew. So I am concerned that if this doesn't coexist or co-allowed for something like the ethics requirement that physicians, nurses do, because I think it goes along with ethics, that maybe we're putting an extra thing in that takes away from something else that's equally important. And that was a question I asked. I don't know if I got a serious enough answer to vote for it. Thank you.
Thank you. Is that a question to the sponsor? 327? Senator Hardy?
So I will be voting no with the right to reserve. There's a sponsor.
Hi, good morning. I'm gonna need the question repeated. I was in a work session for my committee, but I'm here now.
Madam Chair, am I under the impression we're not as important as everyone else? Okay, I better get serious. So my question is concerning the extra and additional requirement for CME, which may replace some other things that are important for learning how to practice medicine, for instance. So I asked the question, I think, during the hearing about ethics, and could this count for the ethics requirement as well as the requirement we have for mental health professionals, et cetera?
Thank you for the question, Assemblyman Torres, for the record, through the chair to the senator. So there's nothing in this piece of legislation that's saying that this would count as the ethics course, but that would be up to the individual boards to determine how these courses work. And in the conversations that I've had with many of the boards, I don't think that that is their plan at all for this to count as an ethics plan. But I mean, that might be a conversation that you could have with the boards offline as well. Additionally, right now, what ends up happening is there's those 20 continuing education units that they're required to have. This is just saying that 2 of those have to be in this. It's not saying that they can't take these other courses, that they're not available, and I don't think that there's anything preventing them from taking additional courses if they so desire. It's just saying that 2 of them have to be in cultural competency.
Thank you. Thank you, Madam Chair.
Additional questions, comments? Okay. I just want to say one of the things that I know that we have lacked here in, well, it's been lacking across the country, but since I'm in Nevada, I'll address that, and that is COVID didn't introduce us to how the healthcare system had, for the most part, failed members of BIPOC communities. It turned the light on, turned the spotlight on. And I think in some cases, what happens is that if people are not aware or at least culturally sensitive to certain ethnic, linguistic, and even when we think about cultural competency, there's a different culture among the deaf community than there is among those who are hearing, and a different culture among those who are blind or sight challenged. And so if we're going to become better, especially since we hear in this session, we don't have money, we don't have money. You know, one of the things that I think we've got to make sure we do is people in all walks of life, not just medical, but I think it's going to be real important for us to begin to seek to understand the different cultures and why people do what they do. I'll say this, and then Madam Secretary, get ready to call the roll. When I was a company commander, I had my first sergeant to come in, and he wanted to discipline one of the new soldiers, and he was going to discipline him because he thought he was being disrespectful. He's talking to him, and the soldier is looking down, and he won't look at him in his eyes. And I had the soldier to come in and immediately realized, in his culture, it was a sign of respect not to look at someone who is in charge or elders. And the first sergeant didn't understand that. And if I had not taken the time to point that out, that soldier probably would have been washed out very early. Fortunately, I had an opportunity to see him about 12 years later. He was a PFC when that happened, and when I saw him in Oklahoma, he was a E8. So I think that's one of the reasons why we've got to make sure that cultural sensitivity goes across all professions, because indeed we are a culturally diverse society. So with that, Madam Secretary, please call the roll. Motion.
Move to do, sorry, is do pass, right? Not amend. Amend do pass.
Yeah. So we have a motion from Senator Scheibel, amend to pass. Do we have a second?
Second.
Okay. Second from Vice Chair Neal. Additional questions? Now, Madam Secretary, please do the roll call vote.
Senator Hardy.
No.
Senator Lang.
Yes.
Senator Neal.
Yes.
Senator Pickard.
No.
Senator Scheibel.
Yes.
Senator Settlemyre.
No.
Chair Spearman.
Yes, and the motion does pass, and I'll do the floor statement. Thank you.
Thank you, Chair.
Thank you, Madam Chair. Cesar Magrejo, Committee Policy Analyst. For the record, our next bill is Assembly Bill 366, which revises provisions governing mental health records, and is sponsored by Assemblywoman Tolles and was heard on April 21, 2021. There is amendments proposed by Senator Spearman. The first amendment is to amend subsection 1B of sections 2, 3, 4, and 5 to require the informed consent to be in writing on a form that complies with the regulations by the applicable board and retained by the applicable mental health professional for not less than the length of time specified by the applicable board's regulations. Number 2 is to add a new subsection to sections 2, 3, 4, and 5 to require the destruction of the recording before the expiration of a length of time specified by the applicable board's regulations. Number 3 is to add a new subsection to sections 2, 3, 4, and 5 to require that the recording comply with existing Health Insurance Portability and Accountability Act regulations to ensure that these recordings cannot be reproduced, copied, or stolen. Number 4 is add a new subsection, sections 2, 3, 4, and 5 to require that the recording not contain any identifiable information relating to the patient unless provided with written consent to do so. Number 5 is to add a new subsection, sections 2, 3, 4, and 5 to require the applicable boards to adopt regulations to set forth requirements for the form to be used to obtain the informed consent, specify the minimum length of time that the applicable mental health professional must retain the informed consent, specify the maximum length of time that the applicable mental health professional may retain the recording before the recording must be destroyed, and define training activity for the purpose of a program of education for mental health professionals. Number 6 is to add a new subsection, sections 2, 3, 4, and 5, to provide for the provisions of these sections do not abrogate, alter, or otherwise affect the obligation of a mental health professional to adhere to all other provisions provided in Chapter 629 governing healing arts generally. Number 7 is to change the effective date of the bill to effective upon passage and approval for the purpose of adopting regulations and performing any preparatory administrative tasks, and on July 1, 2021 for all other purposes. Madam Chair, that's all the amendments.
Thank you. Do we have questions? Yeah, Senator Lang.
I just want to say thank you for those amendments. I think they addressed all the concerns that I had in the committee hearing.
Senator Settlemeyer, then Senator Hardy.
Thank you, Madam Chair. I was just curious with the amendment, will this create the situation where a deceased family member will not be able to get the records? That was kind of a concern that I had, and particularly within the hearing. I was wondering if that amendment took care of those concerns or not.
For the record, Nina Laxalt representing the Psychology Board, and Senator Settlemeyer, I think the president of the board sort of regretted using that as an analogy because that actually would not take place. But yes, no family members would be able to see your health records. I mean, I'm sure there are times that power of attorney and things like that where a family member, gives the consent to turn over their health records, but this does nothing to allow that in any case whatsoever.
And in that respect, those records would not be able to be viewed by anyone other than in training purposes, so not in a big, a group class setting. I'm just worried that somebody may say something in confidence and then have that revealed, then it gets back to the family and it could have irreparable harm upon their memories, and that's my concern. So I just want to make sure that that's clear, that cannot and will not happen.
Senator, for the record, Nina Laxalt, yes, that cannot and will not happen. They do have HIPAA laws to follow. There are all sorts of guidelines in here that no, I mean, if they do that, they're breaking the law. So that essentially, hopefully would not happen. You can't, I suppose, guarantee 100% confidentiality in all situations, but we've done everything we could to protect this system of recording from birth of the recording to the death of the recording and making sure that it's completely controlled. And again, they would have to still be following all the HIPAA laws and their own provisions under 629.
Okay. Thank you, Chair.
Thank you, Senator.
Senator Hardy.
Thank you, Madam Chair. So all of these proposed amendments are making me feel better. I'm not sure I feel better enough, but I'd like the concept. So if I'm a physician and I make a recording of any kind, does this absolve the professional from the liability of having destroyed a medical record?
Senator Hardy, thank you for that. I don't think it absolves them. However, if you look at the way this amendment is going, nothing can be done with that record without the explicit consent of the person being recorded. So they have actually full control and say so over when, if, how, and for how long. I hope that answers your question.
It answers a question. So can these be used as a suit? Can they be used as evidence in a suit? There's two issues for the doctor. Can they be used against the doctor? And can they be used against the doctor because the doctor destroyed evidence?
Senator, I guess I'm having a hard time trying to figure how they would be used against the doctor.
So, okay, I'm going to play attorney then.
Okay.
So I do a training film of somebody who's depressed. And I show the training film to students with permission of the patient. And the students know that that exists. And 2 days later, the patient commits suicide. And I don't even know the patient's committed suicide yet. And on the day after the person commits suicide, then I destroy the record, albeit not even knowing the person's committed suicide. Or if I did know the person committed suicide and then destroy the record, do you see where I'm going?
I do see where you're going, Senator, and I hope Dr. Owens is on the phone, but I'm going to try to, or on Zoom, but I'm going to try to answer that in that we made it very explicit as far as the understanding of the length of time that that video is kept. It's in the agreement between not only the patient but also the trainer. So there's a minimum and maximum amount of time that is agreed upon. So if by chance someone has committed suicide and the the video is then destroyed, that would still be under the agreement that was made prior to that person committing suicide. But I do see Dr. Owens up there, and I will let her elaborate if I'm incorrect in any way.
And if she can speak slowly and closer to the mic before she even starts, that'll probably help me. Thank you.
Great. So Dr. Whitney Owens for the Board of Psychological Examiners. So the way that it's written in the informed consent, the recording is never a part of the patient record. So in the informed consent, it's clear what is a part of the patient record and what's not a part of the patient record. And the recording explicitly for training of a student is never a part of a patient record. So even if the recording took place on a Wednesday, a suicide took place on a Thursday, and the records were requested on Thursday, that recording would never be a part of the record that would be released to anyone.
Did we have the attorneys agree to that? That by definition, a medical record isn't part of the medical record?
Yeah, let me get our committee counsel to weigh in, please.
Thank you, Madam Chair. For the record, Will Keene, committee counsel. There were a lot of questions there, so hopefully I will be able to address them all. And if I missed something, please let me know. So state law cannot cannot make HIPAA not apply. HIPAA is going to apply, and state law cannot conflict with that. So many of the questions would simply be if HIPAA does not allow that information to be released, then it's not going to be released no matter what this bill says. However, the amendment does include specific language so that the bill will be amended to say that nothing here conflicts with HIPAA, which it could not anyway. As far as how this could be used in court, the bill does not specifically address that, but any information which is handled in accordance with law, it seems unlikely to me, and this is just my opinion, it seems unlikely that if a doctor is following the law in destroying evidence and following the law with regard to who the doctor is letting see the documents, that would be taken into account in any court proceeding. Because if a doctor is following the law, then there wouldn't be any malintent attributed to the doctor. That's not specified here in the amendment or in the bill. I don't know if that answers all the questions, but if there are more, I'm happy to explore them.
And that's kind of where I'm going, Mr. Kane, is it's not explicit in the bill that it can't be, shouldn't be, won't be, and that's what gives me pause. Thank you, Madam Chair.
Thank you, Vice Chair, and then Senator Pickard.
Thank you, Madam Chair. So it's kind of similar concerns. I just had the one question on if it's destroyed, the recording is destroyed, and I understand, I guess, the concept that they're going after, but the question that I had is if during the recording, which is a part of the training, you find out information where someone could then assume that you had knowledge that a person was going to harm someone or harm someone else, what then is the relationship for, number one, the recording, and number two, the liability that's put on the trainee who is then using that? Because there could be circumstances where you are recording someone and it's a part of your training where you then are apprised of information or you receive knowledge that a person is intending to harm another. And I don't think I saw the explicit exclusion. Well, if you find out about, I won't even say criminal intent, but it could be something less than criminal intent that at least you're responsible for reporting. And I'll put this in this framework. So even within a school setting, a teacher, counselor, or whatever is responsible for certain reporting requirements if they get knowledge of certain things. And I guess in this context, I just want to make sure that that is dealt with because that could happen. You know what I'm saying?
Yeah, so Dr. Whitney Owens, we are required, we have a duty to warn that whether we're recording the session or not, we have a duty to warn. So if somebody states in a session with a trainee that they have intent to harm someone, the student will immediately come get their supervisor. We don't rely on the recording to provide that information to the supervisor. The student is immediately to come get the supervisor. We problem solve with the patient. We work on keeping them safe. We work on keeping other people safe. If they're unwilling to contract for safety, we consider psychiatric hospitalization. It's documented in the written record of the patient. And so that if at some point later there is a criminal investigation or something like that, it's still written in the record that that occurred in the session. There's just not the recording from the student because the intention of the recording is for training only. But there's still an obligation to keep the patient safe and to keep others safe, regardless of whether we're recording the session. We still follow the same procedures that we would even if recording never happened.
Okay, thanks.
Senator Pickard.
Thank you, Madam Chair. And I'm going to pile on here. As someone who's handled personal injury cases, this was my principal concern during the hearing was the question, does this constitute spoliation of evidence? And to use Senator Hardy's analogy with a slight change, it's unlikely that someone's going to threaten suicide and then action not be taken. But what happens if they don't? What happens if the, and this is made, I recognize this is supposed to apply only to videos that were taken for purposes of training. So my first question becomes, what happens if a physician or a psychologist or psychologist were to inquire, they work with the patient, and maybe they don't ask the proper questions. Maybe they're, because we're talking about a training situation, they just don't do a very good job. And then a couple weeks down the road, the person commits suicide. Would this not be important evidence in a case? My thought is that if the physician or the psychologist were to get from a lawyer a records retention letter, which is a standard practice, we send those letters out and say, save all your records because they're going to be part of a lawsuit, and then the psychologist destroys the record because it was made for purposes of training. How is that not spoliation of evidence?
Whitney Owens for the record. My understanding of the intention of the recording is for training purposes, and we're really trying to walk a middle path here between, we could have trainees seeing patients without any recording, and they could not ask the correct questions for a long period of time. The recording is there to make sure that they're getting good supervision, so that we make sure that they are asking the good questions. If we don't have if we don't use the recordings, one of two things happen. Either A, we just trust that that what our trainees are saying is accurate, which a lot of times it is, and sometimes it's not. And then if we are in session with them, then we're cutting the Nevada workforce by 50%. So the recordings are really there to provide really high quality training, making sure that our students are asking the right questions. They are doing their due diligence to make sure that they're keeping their patients safe and keeping others safe. It is a part of the informed consent that the patient knows that this is not a part of the record. And so from the beginning, legal paperwork that we have patients sign saying this is not a part of the legal record until the destruction of the tape, that's an understood part of the relationship. It's an understood part of the medical record that's not included.
All right, I appreciate that. But often the reach for, particularly under a subpoena, goes beyond the official medical record. It goes to any record, including personal notes and other things which may be litigated later. But let me back up half a step and ask this. I made the assumption, but I want to make sure we're clear. This does not include recordings made for any other purpose, correct? That we're limiting only recordings made for the purpose of training, and that purpose would have to pre-exist the recording. Is that correct?
Let me make sure I'm understanding your question. So your question is that the purpose of the recording is for training only, and I'm sorry, can you restate the question?
Sure, let me ask it this way. I want to make sure we're talking about recordings that are made for the purpose of training only, so that a psychologist could not come back and say, oh, well, I destroyed that because I was intending this to be for training in the future, right? Which would be a great excuse under this bill to absolve themselves of the spoliation charge when in fact there was no intent going in that there was training. So from an evidentiary standpoint, the purpose of training, the expectation that this was going to be used in training would have to predate or pre-exist or exist prior to the actual recording, and that would have to be documented somewhere. Is that the case?
Yeah, that's
excuse me.
exactly right.
Hold on.
We wouldn't do recordings without informed consent at the outset of the relationship.
Okay, so hold on just a minute. I'm going to weigh in here, because what we're doing, we're having another hearing, and we're not going to do that.
All
So
right, well,
I
then I'll just
understand,
be a no
I
until-
understand that the questions are important, but if we can go ad infinitum in terms of what scenarios might be. But what I want to do here is I want to get our counsel to weigh in. These are I appreciate the questions, I respect the questions, but we can't just keep going back to another scenario. Mr. Keene, can you weigh in? And please don't take that personal, but we did this with another bill last week, and it was a mess. So, Will, can you weigh in, please?
Certainly. Thank you, Chair Spearman. For the record, Will Keene, Community Counsel. So hopefully this will address a few of the points that have come up recently. All this bill does, it doesn't change the rules of evidence. It doesn't change disclosure requirements under HIPAA. It simply allows for these very specific mental health professionals, which, by the way, does not include medical doctors or DOs. The chapters those chapters are not amended here. All this does is allow these particular recordings under these particular circumstances to be made and then used in accordance with the rules, much of which is going to be done by the boards pursuant to regulation, and then destroyed. The bill requires that they're going to be destroyed at a time certain, and as in pursuant to the regulations. And that's all it does. It just carves that out. As for evidence, I noticed, I heard that people were bringing up the Tarasoff letters. Those are the letters, they're known as Tarasoff letters, when a patient says that he's going to harm himself or others. And I had a chance to look that up. In NRS 49.213, subsection 6, Nevada law codifies the known concept of the Tarasoff letter, where if a psychologist has a patient who says he's going to harm himself or others, that's not confidential, and the patient or the doctor has an obligation to tell. So as far as the rule of evidence go, that came up too. This would be, if these documents are out there, they certainly would not be any more available than any other record that the doctor had. And the rules of privilege, by the way, Chapter 49 does have a subhead all about the rules that apply for evidence for psychologists, and none of that is being changed. So all of the same rules would apply, and certainly if a doctor had kept notes, this recording would not be any more available than those notes, with the exception of being able to be used for training activities. I hope that addresses the questions, but I'm certainly happy to go in if there are more. Thank you.
Yeah. Thank you. And let me just say again to the committee, and please do this. We won't have meeting. We want to have committee meeting tomorrow. We've got about 14 bills, I think, to work session on Friday. So I would just encourage everyone, go through whatever bills we're going to work session on Friday, go through the amendments, and please reach out to the sponsors, and really pressing questions that will have a particular, carry particular weight on whether yes or no. Please ask them, because if we have a rehearing on every bill, we're going to be here till Christmas. And my birthday's in June, so I'm not trying to do that either. So that's where I am. I appreciate your question, Senator Pickard. Appreciate your question, Senator Hardy and Senator Settlemyer. But what I don't want to do is go back into a hearing, and that seemed like where we were going. Let me ask this question of our counsel. So, Mr. Keene, the bill as it is and as it is amended. And I want to make sure that I get this right, but I think I heard you start your response indicating that the amendment, the bill and the amendments spoke with specificity to what this was supposed to do in training. Did I get that right?
Yes, the bill simply allows, with, by the way, advance notice. I mean, the patient has to sign the disclosure in advance. It can't be done after the fact because that's not how the bill is structured. But with advance approval of the patient, a recording can be made and used for these training activities, which, pursuant to the amendment, would have to be clearly defined. The training activity itself would have to be clearly defined. The maximum length of time that the tape could be retained before it had to be destroyed has to be defined in regulation, and then a minimum length of time for retaining all of those informed consents, so that those informed consents would have to be available, and that's what the bill does.
Okay.
Madam Chair?
Yes.
Would you entertain a motion to amend and do pass?
I will.
So moved.
So I have a motion from Senator Scheibel, second from Senator Lang. Additional questions? Okay, so Madam Secretary, please call the roll for the vote, please.
Senator Hardy,
No, with right to reserved.
Senator Lang,
Yes.
Senator Neal,
Yes.
Senator Pickard,
No.
Senator Scheibel,
Yes.
Senator Settlemeyer, and Chair Spearman.
Yes. Let the record show that the motion does carry. And Senator Scheibel, you want to take that? Thank you.
Cesar Magrejo, Community Policy Analyst. For the record, our next bill and work session is Assembly Bill 442, which revises requirements concerning training of certain providers of healthcare, sponsored by Assembly Committee on Commerce and Labor on behalf of the Legislative Committee on Healthcare. And Madam Chair, there are no amendments to this measure.
Thank you. Committee, questions, comments? Yeah, Senator Hardy? Yeah, you have questions? Yeah. I see Dr. Orlicker, you want to come? Yeah. Yes, please. Did you have a question? No. Is that a question? No? Okay. Moves to approve. Hold on just a minute. I just need to make sure nobody has questions. And please hear this the right way. I don't have a problem with questions. I just don't want us to spend 20 minutes doing a rehearing. Okay. So that was a motion, Senator Hardy? So I have a motion from Senator Hardy. I have a second from Senator Settlemeyer. Additional comments? Okay. Madam Secretary, please do a roll call vote.
Senator Hardy,
Yes.
Senator Lang,
Yes.
Senator Neal,
Yes.
Senator Pickard,
Yes, with reservations.
Senator Scheibel,
Yes.
Senator Settlemeyer, Chair Spearman.
Yes. Let the record show that the motion does carry. Senator Hardy, will you take the floor statement on that? Okay. Thank you, sir. Thank you. Mr. Magrejo, and I think this is our last one. Is it 277? Okay. Thank you.
Yes, Madam Chair, we're done with the work session document that was provided on Nellis. However, the chair has chosen to work session AB 277, which was heard this morning and sponsored by Assemblymen Duran, Flores, Torres, Gonzalez, Considine, Summers, Armstrong, and Thomas. As the committee would note, there is an amendment that's provided on Nellis, which both parties described the amendment. So at this moment, the motion would be amend, do pass.
Thank you. And I think, Senator Hardy, you got a picture of that, right? Okay, all right. All right, so I'll entertain a motion.
Amend do pass.
Have a motion from Senator Lang, have a second from, was that Senator Hardy, was that your? Second from Senator Hardy. Questions, comments? Okay, Madam Secretary, please do a roll call vote.
Senator Hardy,
Yes.
Senator Lang.
Yes.
Senator Neal,
Yes.
Senator Pickard.
Yes.
Senator Scheibel,
Yes.
Senator Settlemyre. Chair Spearman.
Yes, and the motion does carry. Senator Settlemyre, you want to take the floor statement? Thank you, sir. And I think that ends our work session for today. As I said, we will not have a committee meeting tomorrow on Thursday, but we'll be back bright and early on Friday at 8 o'clock. We have several bills that we need to work session. Please look over those bills, and if there are extensive questions that you will need to be clarified prior to the vote, please make sure you reach out to the sponsors so that we can make sure that that happens. Senator, I know that there are several committees that will meet in the afternoon that are going to try to meet in the morning to make sure that we can get the bills out of here that have been presented. And this is just a point of personal privilege. One of the things that I want us to be mindful of is that it's someone else's bill this time that we need to take time to get, we need to make sure we have time to do it. On another occasion, it may be yours. It's this committee this time. There may be, the next time it may be your committee. And so during this time in the legislative process, and those of you who have been around for a minute or two know it gets like this, and we have to make sure that we have the economy of time always. Again, I will say this is not my my calling for the question for the previous bill, next to the last bill, is because we cannot do a rehearing. We cannot do a rehearing. So I have no problem whatsoever with questions, a specific question. Let's get to the point. If it's going to be another scenario, what I would encourage you to do is, if you can't support it, then always reserve your right, and please get with the sponsor so that we can make sure that we're redeeming the time in a very valuable way. So 14 bills on Friday. Please make sure that you familiarize yourself with that, and if there are extensive questions, please make sure that you address those. We have one more item, and that is public comment. Broadcast. Do we have anyone? First of all, anyone here in the room? Don't see anyone. Broadcast. Let's go to the phones.
Thank you, Chair. Your public line is currently open and working, and you have no callers at this time.
Let's give it a couple of seconds. Still no callers?
Thank you, Chair. Yes, you have no callers at this time.
Okay, thank you. So, Senator Settlemyre, what is your niece's name, and what's her degree?
Rosalie Education.
Is that Rosalie? Rosalie Education. So we want to say congratulations to her. She will be graduating tomorrow, and this is only the beginning. At 9 years old, you can't wait to become an adult, and then at 30, you wish you hadn't. So. This is just the beginning, but congratulations to her, and enjoy the time off tomorrow. And so with that, we've done everything we've come here to do. Any additional questions or comments, committee members? Seeing none, we are adjourned.